Yo, what's up? Welcome back. Welcome back. Welcome back. We've missed y'all. It seems like it's been a little sporadic, a little here, a little there, but we're here today. We'll be here tonight because today is Aidan Kearney Day over on Defense Diaries. We are going to be covering the hearing today. See what's going on over there. Allison's like, do you know what it's up for? I'm like, nah, I don't know. And I don't really care. I'm covering it no matter what it is. Because I got his back big time. And now that Karen's case is over, I hope. Oh, there's my beautiful, brilliant co-host. What's up, girl?
Hey, babe. Hey, y'all.
Oh, and by the way, I'm Bob Mata, and this is Defense Diaries. Welcome, 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 welcome. If you're new to the channel, but as I was saying, now that Karen's case is over, at least the criminal case, obviously there's the potential for these civil cases to move forward. But Aiden's case is important in a very different way.
Well,
Aiden's case is important in a way,
both ways, really.
Yeah. But in a way that profoundly can affect us in terms of how we are able to exercise our freedom of speech in this country.
And the freedom of press, for that matter.
And the freedom of press, for that matter. So I'm really hoping, and I get it. And we're going to spend a lot of time with Aiden tonight because, I think people tend to, hear sometimes his vile language and his satire, which that's what it is. I need to have you guys understand that. I'm not going to get into my Hunter S. Thompson gonzo journalist kind of jaunt here. I'm going to save that for tonight because that's who he is. That's what he does. He does gonzo journalism.
It's one to know him as his journalists, his gonzo journalist self, and other to know him as a person. And
right,
with the way, like you said, some of his vile language and things like that. If he's crass, people just write him off. They don't understand how intelligent he is, how they don't understand his whole backstory, which we'll all get into.
We're going to get into it. We're going to get into it, and I'm excited about it. And he's an easy guy from the sidelines to think that you dislike. I have a feeling that if you're one of those people that after tonight's interview, you're not going to feel that way.
No.
Maybe I'm wrong.
I think a lot of people saw his interview with Alan Jackson and say, oh, okay, wait a minute. There's a different side of Aiden.
Yeah, like feminine, I think that's accurate. He is an acquired taste. The one thing about him that's not an acquired taste is the freedom fighting that he does. Because anybody that thinks it's easy to go out and scream at MSP with a fucking bullhorn, if you think you can do that, you think that's easy to do, I suggest you go out and give it a try.
Right.
Because it ain't easy to do.
Regardless of the words spoken, the actions taken were brave.
There's simply no denying that.
No denying it.
So no denying it. So needless to say, we will be covering our friend, and we will be covering his trial because it is a very, very important trial. All right, so babe, why don't you try to pull up the stream now?
Oh Lord.
I've got it up. So WBZ has pool camera. So I don't know. I'm gonna
So
check and
do that
see.
because I'm worried that when you unmute yourself, you'll be taught. For those of you who were not here when we covered Aiden's last hearing, when Bob unmuted himself for the YouTube, he was talking in the Zoom in the courtroom.
That's
So
that's a
I'd
true
rather
story.
avoid that at all costs.
I wasn't sweating it nearly as much as Allison was.
Well, and thankfully it was at the end. I mean, but could you imagine it not being at the end?
I mean, yeah, like I'm a lawyer.
Excuse me, Your Honor. I am
Pardon me.
not
Pardon
a
me. I
cat.
didn't know I was muted.
I'm not a cat.
Oh, I'm not a cat. I'm ready to. Yeah.
How's
Sorry,
that
Allie brought
watermelon?
me. It's delicious,
The strawberries are
spectacular.
uh,
With the bite, with the strawberry and the watermelon. Mm,
I had to bring up Bob the last of the watermelon because it was so good. I wanted to eat it all, and it would have been so unfair.
I was showering. She leaves the bowl outside of the. So we're still going through uh our air conditioning nightmare. However, the weather is broken a bit. We've finally gotten out of the mid 90s, and we're in the low 80s, which is pleasant. Which is pleasant. So it's been challenging though, my friends. I will tell you that. Uh, if they would have had me on video for some of that shit, oh boy. There was one day in particular that I was not a pleasant person to be around, man. It was a day of really just vexing heat, and I wouldn't want to be around me. I didn't really want my family to be subjected to me. It was awful. It was a terrible, terrible day. It was a full day of just sweltering death. And I can't remember, was that the day that we put up the blinds? Yeah, we had to go buy
Yes,
these like
yes,
blackout blinds from.
yes.
It's
I
been
was about to start hanging sheets, cold sheets in the house. You're muted. Oh boy. Does he know he's muted? This is trying to get to the sound bite. How do I get to it quickly? I mean, he can hear me, so he must know he's muted. You're oh, I'm trying to find it. What is this new setup they have? Oh, I can't find it. Oh, Bob, you're muted. Bob, you're muted. All right, well, just pull up the pool camera. Stay muted. I'll run this. I'll run this show. I got this. We don't need your sound. Bob, you're muted. But if he stays muted, that's all I'll be able to do. I got this. I'll just keep saying, Bob, you're muted. I know I'm muted. I know. Turn my sound up. No, don't do that. Just pull up the pool camera. Show us OnlyFan. I thought he was trying to get on Zoom, so he had to stay muted. Oh, that is what you're doing. Oh, you stay muted. Okay. All right. And for those of you who are just joining, Bob's joining the courtroom Zoom, and he will remain muted so as to not talk in the courtroom through the proceedings themselves. But we've got when I was saying earlier, we've got like both things going. We've got the freedom of press and the freedom of speech is one thing. Like that's one, but you also have abuse and police and prosecutorial abuse and misconduct. And this this bullshit cannot stand. This injustice cannot stand. So we need to bring as big of a voice as possible to Aiden's case as Aiden brought to Karen's case. Now, who knows? I'd love to see a packed courtroom today. That would make my heart happy. And I feel like the community out there probably will turn up. We probably will have a packed courtroom. I'm surprised we don't have up like, there's a whole conglomerate of people outside of the courthouse too. I'm sure there are at least some. I don't know what he's doing, people. He's really not getting that shit up yet, though. Let's see. Yes, Amanda, the free turtle boy. Thanks, Sliber, Sleuth Steph. Welcome. As someone who has, so Amy's positive pathway says, as someone who has met Turtle Boy in person, he is calm. Yeah. John Miller, glad to be back with the Defense Diaries and the chat. Bob, hope your dad's feeling better. Free Turtle Boy. Leslie Tompkins says, they illegally recorded him at the pizza shop because you can't have sound. So what can he do about it? Chris A intimidates tourists all the time. Yeah, for sure. Well, I know that they made a motion on that, as far as it not being allowed in. And I think if I recall correctly, at the bond hearing, the judge did not listen to the sound of one of the cameras. I don't know. But his lawyers are obviously, on top of all of that. I mean, more of the problem is that he's dealing with a statute that was not designed to cover a journalist who uses satire and, things of that nature. These people do not feel, um, threatened. They feel annoyed. Okay. They feel called out. They feel bothered. Okay. And if everything that Aiden thinks happened, would this ever be an issue if they were ultimately the defendants? I mean, Karen Reed has now been found not guilty by a jury. They have to take into consideration whether this statute should apply in this situation. It's what we would call a constitutionality as applied, that the statute is unconstitutional as applied to the facts of this case. This is not a case where somebody was trying to have any sort of conduct to try and deter witnesses to a crime from coming in and giving their honest testimony. It was trying to get an investigation into other suspects of the crime and get those people to confess, come clean, at least not continue to lie, whatever the case may be. But hey, can you unmute and at least tell me what's taking so long to get the thing up? Are you in a waiting room? Is there another feed you can put up? I don't know how the basement gets hot while I'm sitting in here, but gotta put my hair up. So hot down here now. All right, well, get to a certain age, and the temperature of a woman's body changes whenever the fuck it wants to. So, and yes, for those of you wondering, some people have tagged me in the person on Twitter who does the perimenopause rants, and they are hysterical. So I do not care, but I do care that I'm getting hot and bothered. Oh, there's my man. Please hold. Hey, babe.
on the Carney matters. Okay.
This one.
We're going to do Mr. Carney. So next before the court, number 6, 7, and 7.
All right, I left. You guys can't hear it? I can't hear anything. I don't hear it. You guys hear that? No sound, babe. Wait, some are saying they hear it. Did you follow it as a web page? Let me see if Will's got it up.
Okay.
Thank you.
Would you like
Will's
me to
got
do
it
that
up.
now or wait for you?
Why don't you do that now? Just do them one at a
All right,
time.
the court recognizes you personally without surety with the following conditions. You are to have no contact, direct or indirect, with the victim in this case. You are to stay away, stay away 100 yards from the residence and the place of work of the complainant. You sent to those
My man
conditions,
can't
sir.
have a Santa Fe.
Okay.
You're hereby notified if you're charged
No
with a
more
crime during the
STF
period of your
McCarthy's
release.
is some
Bail in
bullshit.
this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 68. Thank you.
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay,
Obviously, we can push those to
The
another
judge
day
was like,
with 2
yeah,
small
right,
sections
the
of
waiving
just
of
in order to
yeah,
preserve notes of
pizza
investigators
shop.
and to preserve video, if I may, Your Honor. I don't believe there's an objection.
okay. Yeah, those are both ordered. So
Thank
he's ordered, the Commonwealth's ordered to preserve notes of investigators and to preserve video. What else can I do for you?
I love this shit.
Why don't I start with you, Mr. Cosgrove? Go right ahead.
All right. So,
Thank you for the
Your
Venmo,
Honor,
Elizabeth.
Entered a discovery order the last time we were here. Let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradel today. And I had planned, Your Honor, to file that with a motion for a protective order, which I had
Allie, you got some other shit running.
a couple of minutes from the one I gave you.
Thank you.
And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicates of discovery turned over in the Karen Reed case, and I pretty much follow their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradel wishes to bring that practice to an end as of today. I'm in a somewhat different position.
All right, let me hear from Mr. Bradel. Mr. Bradel,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moot. It's gone, okay? And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it, but I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents. And that's really all the Commonwealth has left on the existing stuff, is that, you know, gee, this might make investigators look bad. This might make special prosecutors, present company accepted, look bad. This might, you know, cause election shifts, you know, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, you know, from the Commonwealth, and when they say, just, we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor. You know, this is a case of immense public interest. This is a case of, you know, First Amendment issues, and I know we may disagree on that, but you know, that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with you, so that's okay. And, you know, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and, you know, these text messages about, you know, and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to, you know, publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other.
You can speak.
And the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a written response.
I'd give you that. Was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement. And if you want to file anything else, Mr. Bradle, Mr. Betterow, you absolutely have every opportunity.
Thank you very much, Your Honor. And
now, Your Honor, with respect to the items that I was going to turn over today.
So I'll allow the motion. Mr. Bradle, I'm up here.
Sorry, Your Honor.
It's all right.
I thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Betterow. My point is this. If you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
All right. Please note our objection, but thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very much.
Does that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off. I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out. Yeah. You know, I think we're going to agree to go in person with our people and figure it out. So sure. That's the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with Our Third Motion to Compel. Okay. There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24. And second and third, you know, were the months following. And you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time, but you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, and maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
Yeah.
Could you give me an extra week, Your Honor?
An extra week.
Thank you.
All right. But it is, Mr. Bradle makes a very good point. As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradle has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery turned over in this case.
Yeah. If you turn over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Better has a number of items as well, Judge.
Mr. Bettero.
Thank you, Judge. Just going back briefly to some of the issues about impoundment.
Yeah.
There are some items that are currently under impoundment, which we believe ought to be released from impoundment, specifically messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Carney's interest and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has, the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. So those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward, and there's no reason for those to be impounded at this time.
Okay. Anything you want to say to that, Mr. Cosgrove? I'm not going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other matters.
I think that makes sense too.
Yeah, I won't ask for another week. I won't ask for another day.
That's, why don't I do this? Why don't you all come up to sidebar? Let me take a look at what you need.
Sidebar.
All right, maybe he looks at it now and says, I don't need 3 weeks. I don't need your response. I wonder why you couldn't keep yourself muted on
How
the
did
Zoom.
you get it up? Did you dial
Because I found the way to do it on the internet and not the app. It just kept opening my app.
in? Yeah, I couldn't pull the app up.
You don't want the app or you can't hear the sound.
Yeah. Well, I could hear it, but y'all couldn't hear it.
Right.
I couldn't share it. But if I unmuted, I would have been speaking in court again.
I wonder why they're not showing us the courtroom. Usually on Zoom, you can see the judge and the lawyers who are standing, unless
Yeah,
all those
weird,
lawyers are on Zoom.
Austin 10s says they're live, but I'm not seeing shit. Like I'm not seeing any kind of live stream.
So let's talk here. The participants. We got I don't know who we got. Nat. Maybe that's that Natalie. AML Media. I should have changed my name to Defense Diaries. But
Yeah, should have.
should I change it now?
Nah, I think everybody knows.
Well, no,
Well,
but I just don't want it to be like I'm,
why?
I don't know, because I'm not in here as an
Hey,
attorney.
counselor, it's fine that you're in there. It's public. It's a
Got
public hearing.
Mike Crawford, JSTV, Baker
That's Linda
Media.
and Michael. Mike Crawford is Young Jerks. Will's in there, obviously. Will's like yapping through the goddamn hearing, though.
We lost 300 people for our sound debacle.
Oh, well, what are you going to do?
Uncivil law.
Kurt, our man Kurt's over there.
What's Melanie as? I know she's in.
She's in here. She has to be. Yeah, she's maybe she's under a pseudonym.
No.
Maybe does it say cupcake somewhere?
No.
A little picture of a cupcake.
Huh.
I mean, she's on. She's got 15,000 people on there.
You go back. Mr. Betterow, the floor is yours. What else?
Thank you. Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainant during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. Cosgrove.
Can I inquire if Mr. Mello is online?
I do not see him.
We didn't see him.
Attorney Mello, last time he did use his name, there is no one with his name on there this time.
Can I approach?
Of course. Come on up.
All right. Another sidebar.
Sidebars.
So they're trying to decide whether he's met his burden to be able to call Mello as a witness and subpoena him, because you have to reach you have to establish certain things before you can call someone from the prosecutor's office. So, well, this judge seems like he's paying attention. He has seemed fair so far from what we've seen.
Yeah, it's going to be interesting to see how much of the First Amendment argument he's going to be willing to entertain at trial. Because the question becomes at trial, how do you make that argument beyond closings? You know what I mean? It's like typically your constitutionality arguments are going to take place pre-trial.
What's this judge's name again? I forget
too, because he was in front of a different judge one time, but this is This
And
is
usually
exactly
the
OG.
Zoom link will say which judge it is, but it's like courtroom one's personal Zoom link. And then it just says host. It doesn't have the judge's name.
Nexus says Kaplan.
Kaplan. All right. Kranken points out, and she's been a member for 15
Kraken.
months.
Kraken.
Kraken. Sorry.
You'd think after 15 months you'd know it was.
Hey, everybody
Kraken.
knows I got brain fog.
Oh, man.
Sorry, Your Honor. I have brain fog. What was with the cat? Did someone actually put up a cat as their emoji?
Gato.
Did you see that? Well, yeah, I
Yeah,
blew
I
it
saw
up.
it.
I circled it. I mean, y'all
Yeah,
saw
I
it.
mean, it was hard not to see.
Anyway, Kraken says Turtle Boy on Ian's live said he's an entertainer on camera. Yes, yes, he is. That's his.
Mr.
Yeah, that's-
Federal, you said you had one more thing.
Yes, Judge. Just as it relates to discovery, we have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Carney. Those demands, which again are in the files, Mr. Cosgrove has them outline in detail her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Carney, voice recordings that she has left Mr. Carney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is
way more
obligated to
shit.
do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuri Bukhenik, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Carney's case, and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Carney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real, they're obligated to do it. And we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. Cosgrove.
It's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha. Okay, that's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go right ahead.
Yes. So this will be an opportunity, Your Honor, for myself and Mr. Betterow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth, was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradle's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall the fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to accuse an assistant DA of jury tampering and the district attorney of having secret meetings with witnesses.
Why?
And all these other things.
Except when they
and then
are.
hide behind an impoundment order.
Okay. Let me hear from the other side. Mr. Betterow.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do. And at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement. And almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay.
Just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay. If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at least one point the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say is that the identity of this person is all over the internet, and was all over the internet at the time it was before you the other day. I don't know what the interest is, given those circumstances, in concealing it in the court papers.
Okay. Judge, I'm sorry,
And I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah, go ahead.
Apparently, these things that were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in. And I think the implication was made at the time. First of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Just very quickly, Your Honor, in terms of this individual's name being on the internet, there are two reasons for that. The first is because Ms. Peters identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally through no fault, with no malintent, is not a reason, I think, to just open up the affidavit to her name.
Okay, thank you all. So we have a date for, what was that, August? What was the date, Megan?
August 13th for
August
discovery
13th.
compliance.
And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yeah.
Towards the end of the month?
Now, or do you want to pick it on?
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some information about
That's fine.
the health status at that time.
All right. We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
Oh, sorry. I believe we have an agreement,
Hey, you cut it off. What'd you do? Got a itchy trigger finger there.
he's indicated there was the same source code previously provided Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
So
And I don't think
Mr.
there's a disagreement with that.
All right. You don't disagree with that, do you?
Sure.
Yeah, all right, good. I'll see you August 13th.
Thank you.
All right, take care. Bye.
2 p.m.
2 p.m.
Thank you.
2 p.m.
All right.
p.m. So that was basically what they call a status hearing. A lot of housekeeping. Obviously, Aiden's defense team is trying to get their hands on this discovery. Sounds like quite a bit was tendered today.
5,000 pages. They're like going to just try to bury them in bullshit. They'll go through it all.
Yeah, it's
I mean-
5,000 pages of text messages and all kinds of other bullshit.
Who knows? They hide the good stuff in with the bad, with the meaningless stuff.
Yeah.
All right.
Yeah, they
Give them
bury
these
it.
5,000. Let's see if they can find the two that matter.
It's the move. It's the move.
Yeah.
The
You
needle in
know,
the haystack.
it's getting beyond the time where prosecutors just don't get to be like, Your Honor, this is ridiculous. Now we're going to be like looking into corruption. We're going to act like there's corruption going on in the prosecutor's office or in the Massachusetts State Police. No, that time has fucking passed.
Yeah, buddy.
You don't know. That's not outrageous. That's not impossible. We just saw it happen.
Yeah. A lot. Not just in
and
Karen's
it's happening right here. Like when you have people setting up the defendant, you need to question and look into the entire prosecutorial team, police and prosecutor. Sorry, all of it.
Yeah. True that.
Right.
That.
I know, Michael.
Yeah,
Michael's referring to the discovery where in Richard Allen.
Yeah. If you guys have not heard, Yuri Bukhenik, affectionately known as Bukhenik, has been reassigned by the MSP. It's been rehomed.
He gone.
Third MSP trooper to be reassigned. Well, I mean, initially Proctor was reassigned and then he was shit canned. So, yeah, Boston 10, I think, is showing. Let's see what they got going.
That's all right.
On.
Everybody's known it since this morning. They're with it. These 1,000 people know that shit. I forget though. Where was he reassigned to?
Let's see. I can pull it. Here, we'll pull it up real quick.
This whole temperature thing. Now I feel cool. Put my hair up because I was dying.
Our house is,
this is just my body, though. I think, really.
Okay, let me see here. Okay.
For you right now at 11, this is huge news in relation to the Karen Read murder trial. Massachusetts State Police Sergeant Yuri Bukhenik has been reassigned. Mass State Police confirming the news to us in just the last few minutes.
That true?
It apparently took effect yesterday. Bukhenik was, of course, Michael Proctor's supervisor during the investigation into Karen Read. Bukhenik took the stand in both trials and admitted to being on a text chain in which former Trooper Proctor used unprofessional, vulgar, derogatory language to describe Read. Under oath, Bukhenik said the investigation, despite everything we knew, was carried out with, quote, honor and integrity. Although Proctor was fired as a result, Bukhenik acknowledged he was also disciplined in relation to that.
There you go.
I think it's because next witness asked, do you think Bukhenik's rehoming happened because the Anna Walsh case, the final straw, so to speak? I just think they were waiting for this case to be over to do anything to any more. I'll take my hair back down.
Yeah. All right. So let's see. I think all right, so the way that it's going to go down tonight, again,
I think it's in relation to Karen Read is what I was starting to say anyway.
Yeah.
And they were just waiting for it to be over, but who knows? I mean, could be.
Yeah, it's hard to say. I mean, look, they realize it's a bad look. All these guys that were associated with that case, they're gonna distance themselves and they're gonna put them in positions where they can't cause any more harm. I mean, they stink. They stink. Any case that they're associated with moving forward will carry that stench that's stuck on them, like the Seinfeld episode with the valet, where he just had to get rid of the car because the stink wouldn't go away, no matter what he did.
Stinks everywhere. Stinks everywhere.
The stench. All right, so tonight, Aiden's coming on 8:30 p.m. Central Standard Time. That's 9:30 Eastern Time. I'm certain it's going to be an excellent conversation. I think that you guys will enjoy it.
Yeah, our hope is to get to know Aidan Carney, the person, more. We'll obviously definitely touch on some of the case itself, but we're hoping to have an intellectual conversation about what he's going through in relation to this. So yeah,
Yeah, I mean, the bottom line is it's pretty terrifying when the government flexes its muscles in order to try to silence somebody who's reporting on government corruption.
The irony.
Should
The
scare the
fucking
shit out of you.
irony of it. They're like, oh, this guy's trying to intimidate people into not talking. Really? What are you doing? Big arm of the government, Mr. Man? Like literally incarcerating, arresting, and trying to imprison someone to shut them up. And that's the long and the short of it. They didn't like what he was saying, and this is what they decided to do. And there's messages of them plotting to do it. It's insane.
It's insane.
It's insane.
It's insane. So yeah, it's going to be a great convo. Because if you think it's easy to start a movement, go out and try it. Go out and try it.
It's kind of
I
hard.
challenge you. It's pretty fucking hard to start a movement, and that's
Like-
exactly what Aiden did. And I'm here for it. Allie's here for it. We're here for it because you saw in real time in the Karen Reed trials 1 and 2 exactly how hard it is to beat the government when they've got their sights set on you.
Does anyone see? I would have liked to see the outside of the courtse. I would like to see,
Exactly, Michael.
but Aiden will have to tell us how many
Michael,
people were
I'm
there.
calling you as soon as I get off this live, by the way.
Yes, exactly. Which Bob just said, yes, exactly. But I'm kind of behind noticing Michael's. But
Yeah.
but it's for sure. The chilling effect of this kind of behavior is not lost on people. Well, shit.
Well,
I better not shout out too loud because they're gonna, even if he gets off at the end of the day, they still put him through hell.
yeah.
He spent 60 days in jail. In like, I mean, I don't even understand why he's in the medical unit. It's like their form of segregation.
Yeah, it's crazy. It's crazy. It's a scary proposition.
Scary proposition.
So, which is kind of our point. We keep trying to tell you guys.
They know.
I don't give a shit how you feel about Aiden personally. The
Or Turtle
chilling
Boy because they
effect.
don't know Aiden. They know Turtle
Yeah,
Boy.
I mean the chilling effect of what's happening to
Please,
him
public.
because he was a loud voice should scare you. It should scare you because it scares me. It's like I had a microcosm in the Delphi case. I mean, I had
People were getting harassed.
Yeah, I was getting harassed constantly.
No, but I mean, police were harassing people that were,
Yeah,
speaking out.
It's scary. It's scary. So yeah, I'm really looking forward to it. I think it's going to be a great conversation tonight. We'll keep him as long as he wants to hang, and we'll let him say whatever he wants to say. And you can be guaranteed we'll have some good questions for him. And I'm sure I'll be on my soapbox, whether you like it or not.
I'll push him off. Don't worry.
Oh, bullshit. I'm staying on there as long as I want. It's my channel. I can cry if I want to. So, all right, you guys, make sure you set your notifications. Make sure you like, share, and subscribe. All of the YouTube things. It's bound to be an excellent night tonight. I can't think of anything better to watch tonight, to be honest with you. I've kind of perused the
Luna
YouTube.
will be back. She says it's our anniversary. 1 year anniversary.
Aw, 12 months of family hugs to you, Luna. We love you.
All right,
We love
guys.
you.
We
Love you.
see you all tonight.
All right, y'all. Like, share, subscribe, hit your notifications so you're notified when we go live. You won't want to miss it. And it's fun. It's fun to be in the chat. We love Replay Crew, but it's awesome when you're here when we're live too. So we will see y'all tonight because without you, I'm just an old man.
Standing on a soapbox, yelling into a void.